Hello, I'm State Senator John Kavanagh, and welcome to another edition of Kavanagh's Corner, my video legislative report to my constituents. And this edition covers the week of April 3rd. So let's start with a bill that I had in the House Appropriations Committee. This bill concerns the use of pronouns in K-12 schools for students when the pronoun or the first name does not align with the biological sex of the student at birth. In other words, calling a male Sue or vice versa. So this bill simply says that before a teacher or staff member can call a student by a pronoun or first name that is not aligned with their biological sex at birth, they must get the permission of the parents. Now, this is important for parental rights and student safety. Parents have a right to know if there are significant issues in their child's life. And the child not knowing what gender they are, questioning that, or believing they are a gender different from the biological gender at birth is a significant issue in the life of the child. Parents need to know it. Schools should not hide that from parents. But there's also the issue of student safety. These students who question or have different conceptions of their sex, these students are called transgendered people, and very often they suffer depression, sometimes even suicidal thoughts. So if a school knows that a student is in this category, the parents need to know so they can support and help the child and perhaps get the child outside psychological help. And in fact, in some cases, the parents may know this and they may have gotten outside psychological help, and the doctor that's treating the child may have said, do not use pronouns that do not align with the child's biological sex at birth. It would be harmful. So for the school to do this without parental permission would actually be harming the child. The other part of this bill simply states that a school employee who has religious or moral objections to calling somebody by a pronoun or first name that is not aligned with their biological gender at birth doesn't have to do so. So that bill passed out of the House Appropriations Committee. Next week it'll probably go to the floor for cow and third read action. The next bill that passed out of the House Appropriations Committee was my SB 1588 Criminal Justice Data Collection. The government collects an enormous amount of information on the criminal justice system operations. There are police reports on who's arrested, what they're arrested for. There are prosecutor reports on how these people are prosecuted. There are court reports on the sentences that these people receive, or guilty versus not guilty verdicts. There are probation and parole reports about how they perform. There are correctional reports on how long they stay in jail when they're released. All of this data is tremendously useful to policymakers who want to devise programs or bills to deal with crime. But if this information cannot be gathered by people, then they can't use it usefully. And unfortunately, all of this information is currently housed in different agencies in different databases. This bill will create one statewide collection database so that policymakers, lawmakers, or even university researchers who are trying to study crime will have access to this. Because the bottom line is, in the world of computers, garbage in equals garbage out. And part of garbage is missing data. Missing data will throw off all the research. So this should help us create better policies. Moving along, we also have unjustified actions parental rights. This bill gives teeth. This bill protects parents who use the current law, which gives them certain rights, to protect those rights. So under current law, parents have a right to know what's going on with their children's educations, to direct certain parts of the education, to not have their children be given certain courses or programs that they don't approve of in a school. The remedy for parents who believe that their constitutional rights have been violated concerning their children is to sue the school. That's the remedy that they have. However, under existing law, if they lose the lawsuit, they have to pay not only their own legal expenses, but the legal defense expenses of the school. Now, this can amount to tens of thousands of dollars, and they may have only lost by a hair. These are civil suits where whoever has more than half the evidence in their favor wins. So a parent could have had 49% of the arguments in their favor, where the school had 51. The school wins, and now the parents get hit with $50,000, $60,000 in paying the legal fees of the school. This has a chilling effect on parents exercising their parental rights or protecting them. So my bill simply says that you can only charge the parents for the defense costs in a case where the parents lose if it is a frivolous lawsuit. The judge says it's frivolous or malicious. And this is consistent with certain other areas of lawsuit reimbursement law. My other bill, SB 1021, is also moving forward, and this requires the Attorney General to defend state laws that are challenged for their constitutionality. I had that happen to me last session when Attorney General Brnovich refused to defend one of my bills that would have made it illegal for people to get very close while filming police officers engaged in dangerous activities like violent arrests. The ACLU challenged it, and the Attorney General refused to defend it, so the whole case was lost and the law is nowhere to be found. The Attorney General's responsibility is to defend these laws, and this bill ensures that they can. But there are safeguards where they can back out if they so want. So that's what's going on that's what went on this week. And again, I have many, many more bills going through. So tune in to next week's edition of Kavanagh's Corner, where I'll keep you up on the comings and goings of the state legislature. Thank you for watching.